Justice of the Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, come to their attendance, and they shall be heard.
Good morning. Please have a seat. Takes some getting used to. Welcome to the Appellate Division 4th Department. Just a couple quick reminders. One is the judges make a real effort to be familiar with the records in the briefs, so we don't need a recitation of the facts unless you're asked. And we ask that you get right to your contentions, and specifically your best contentions first. Also, don't forget we have a rule, a long-standing rule against rebuttal, which you can apply to make an application to do a post-argument submission. With that, I think we're set to go. I have the first case for argument as 164. The defendant appellant has submitted, and I think Ms. Orlowski is by video.
Thank you, Your Honor.
We hear you, but we don't see you.
That was just me.
I apologize, Judge.
Not at all, Ms. Orlowski. Thanks for making it work. Can you hear us okay?
Yes, can you? I can hear you. Can you hear me?
Yep, we still can't see you, but we're going to go ahead because Mr. Staff, go ahead.
I apologize, Your Honor.
No problem. We're all doing the best to make it work. But Mr. Stachowski for the appellant has submitted, so the floor is all yours, Ms. Orlowski.
Thank you, Your Honor. I will submit on my briefs unless the court has any questions.
Any questions? We're all set. Thanks for making yourself available.
Thank you, Your Honors.
Next case for argument is number 168, People versus Ivanko. And Ms. Van Leven, you're by video, is my understanding.
I don't see her.
Neither do we.
I think the connections are all cold, is my guess, given the weather. Ms. Van Leeuwen, I see you're on mute, and I can't see you. If you can unmute yourself to let us know you're there, please. We're off to a good start here. All right, Ms. Van Leeuwen, we're going to go under the presumption, since I see your name on the screen, that you can hear us okay. If not, please find another way to try to connect. But Mr. Greenberg, you're all set to go at the podium. We're ready to hear your argument, sir.
Oh, thank you, Your Honor. I'm representing David Ivanko in his appeal. The only, I think, real issue of contest in this appeal, because the people conceded that the appellate waiver was not valid, and that seems to be a recurring issue with the, so I would go straight to the only real issue of contest is whether my client truly voluntarily entered the plea, because he did disclose during the plea argument that he has a learning disability. And
you're arguing the Lopez exception is saying that given his indication that he had a learning disability and his expression of confusion, we should look at the plea.
That is correct. I mean, I think that he really understand what he was going on. I think the one quote he gave is, in my opinion, I don't know what to think, Your Honor. The answer, he never really, I mean, Justice Bowler never really went further. And, so I think that this is to be a reversal. That would be the issue that it would be reversed on.
Thank you.
Thank you. Any other questions?
I think we're good. Ms. Van Leeuwen, there you are.
Yes, Your Honors, I apologize. There is some technical difficulties happening over here, I think, on our network.
No problem at all. The floor is all yours. Go right ahead.
Your Honor, as we said in our brief, we conceded point one as that appeal waiver was overly broad, but this is still unpreserved, and it does not, we would state that it does not meet that narrow exception because it wasn't apparent that there was any issues or questions with regards to the voluntariness of the plea on the record. We would state that the plea was voluntary. Only at one point during the transcript did the defendant say he couldn't understood. The judge stopped, said, hey, if you don't understand, we can't proceed now. Do you understand what I'm saying? Do you have any questions? And then the defendant said yes. The defendant was also represented by competent counsel who didn't mention anything at that point. The record is bare of any other issues, and it's also bare of any other indications that the defendant didn't understand or that the plea was involuntary in any way. This plea is very much akin to People v. Hunt, the 2024 case that you guys just did last year. If Your Honor have no further questions, we'll rest on our brief.
I think we're all set. Thank you very much.
Thank you, Your Honor.
Calling next, case number 169, People versus Radford.
Morning. May it please the court, Sabrina Bremer on behalf of Mr. Radford. In light of this court's recent decisions in People v. Walker and in People v. Flowers, I wanted to focus today on the validity of the initial certificate of compliance, because there were multiple discovery violations that happened below, but there was discovery that was not turned over before the initial certificate of compliance was filed that could have been turned over had the people exercised due diligence before filing that initial certificate of compliance. And this discovery includes the photographs of Mr. Radford's car and the discovery related to the damages estimate to the police car.
Counselor, I want to stay here, but just to clarify something in your brief, on page 14, you indicate that the people had some of the material in their possession.
Yes.
That's not what I just heard you say. I think I heard you say they could have obtained the material. Did they have some discovery material in their possession that they didn't disclose at the time they filed the COC?
So the people represent that they weren't sure who Scott Courser was at the time they filed the initial COC because they didn't do any investigation into who had done the work order estimate. And the photographs were RPD photographs that were taken.
Well, the affidavit didn't exist.
The affidavit itself didn't exist, but the workup of the police car and the estimate took place in April 2020, months before the initial certificate of compliance was filed. And defense counsel noted that that affidavit that Scott Courser put together had information that was not turned over before the initial certificate of compliance was filed. And as for the photographs, those I think would be deemed to be in the people's possession and control because the supplemental COC refers to them as RPD photographs, and the trial court below found that they fell under the automatic discovery, and that finding cannot now be disturbed on appeal. So this discovery, all of the Bay factors do not cut in favor of the people here in terms of this set of discovery. This isn't a complex case. Any of this missing discovery would have been obvious to a prosecutor exercising due diligence. It was turned over upon inquiries from defense counsel, and the discovery was not expeditiously turned over. So while, say, for example, the affidavit was turned over and created after that initial COC, it was in the people's possession that they could see it for months before it was turned over.
Right, but I'm sorry, but that's conflating the two issues, right? Because the affidavit itself wasn't prepared until months after the COC was filed. So
Sure.
if under the Flowers or People v. Walker analysis, that's not really relating back to the COC. Let's focus in on the time the COC was filed.
So on the time the COC is filed, the discovery statute says that the people have an obligation to make good faith, diligent efforts to find that automatic discovery if it exists at that time. And so Scott Courser, he already had knowledge of the damage estimate to the car at the time the initial COC was filed. Those photographs were already taken, and the people identified no affirmative steps that they took before filing this initial COC and until the eve of trial. So on those discovery violations alone, there wasn't due diligence before that initial COC was filed. And I think the affidavit, when you're looking at the fact-specific inquiry, is another factor that cuts in favor of finding that there was no due diligence, because it's not just this discovery that wasn't turned over before the initial COC, it's repeated violations that happen throughout the course of the proceedings below. And then briefly on remedy, I think the remedy here is either remittal or dismissal. I think that dismissal is more appropriate for a few different reasons. Number one, the trial court erred in denying Mr. Radford's first motion to dismiss. There were periods of time that the people contended were adjournments at the request of the defendant, but Mr. Radford's counsel didn't make any affirmative statements on the record for those 4 time periods, totaling about 100.
To get to dismissal, would you agree that you have to establish the possessory prong? That's getting back to Justice Del Conte's questions. In order to get to dismissal in the 3030, you have to tie it into the initial disclosure. Do you agree?
Yes, and I think that this discovery was either in the people's possession or it was in the RPD's possession, and by virtue of that relationship.
And that's how you get to dismissal,
Yes.
by winning the possessory prong.
Yes, by winning the possessory prong, and then also because the people did not properly respond to Mr. Radford's second motion to dismiss, which again laid out all of the discovery violations, including before filing the initial COC. And they didn't identify any legal or factual bases for excluding time. They relied on a short sentence of only 110 days are excludable, and that didn't meet their burden of showing sufficient excludable time. So unless there are any further questions, I will.
Counselor, all set. Thank you.
Good morning, Amy Wollensack on behalf of the people. Justice Del Conte, I had a feeling that Walker might be discussed here today, so I did reread that in advance. It would be our position that neither the photographs or this affidavit were in our possession at the time that we filed our COC, and I believe it was November 9th, 2020. I would defer to the record on the exact date. The affidavit was created roughly 3 months later, and I would note that even if Mr. Corser should have been identified as a witness sooner, all of the information that was underlying his affidavit was turned over before we filed our COC. I believe that one of the discovery documents said that we intended to call somebody to establish the cost of the damages to the police car, and that we would identify that witness later. So defendant was on notice that we were going to be establishing these costs and had the emails. So I think he had the information that he needed to show that we tried to comply as best we could at the time until.
What are we to make of the supplemental COC when the photos, the impound photos, are identified as RPD photos?
My understanding from the response and in reading the entire argument is these weren't RPD photos. These were taken by, I believe it's Randy or Rodney Johnson, who worked at the RPD city, or I'm sorry, at the city impound lot. And none of the investigators that were involved with this particular investigation had any idea that the photographs were taken. They did not direct this Rodney Johnson or Jackson, whatever his name is, they did not direct him to take these photographs. So I don't think that we can be charged with knowing that somebody would sua sponte on his own, unbeknownst to RPD, decide to take photographs of the car and create potential evidence in this case when he was not being directed to do so by RPD. And my understanding is these are impound photo lots that are taken by the city impound lot, which is sort of its own separate proprietary agency, and they take these photographs to show what condition the car is in when they get them, so that the person who owns the vehicle can't come back and later say, you damaged my car. These weren't being taken as part of an investigation, is my understanding.
Is the city pound part of or under the control of the police department then?
The record's not entirely clear. It appears that there was some additional submission to the court after the argument, and the court seemingly found that it was in connection with RPD, but it wasn't clear exactly how RPD is related to the city impound lot. This isn't the evidence lot where they would store the vehicle.
Right, so if my car was illegally parked on the wrong side of the road and it was towed to the city pound, city impound, they would, as of course, take photographs of vehicles then?
That is my understanding, Justice Montour.
Okay.
And in any event, the ADA, I think at one of the transcripts said that this person is not law enforcement, and that was never countered.
No, he's not. He's an employee of the city impound lot. So I would say it's not particular. It would not have been particularly obvious that these photographs were created in connection with these cases, such that it would have been unreasonable to miss that they existed. It would be our position. I'll rely on my brief with respect to the remedy. It would be our position that because the COC was valid, we don't get to the 30-30 dismissal. And like I said, I'll rely on my brief unless the court has any questions.
We're all set. Thank you. The next case for argument is number 170, People versus Harris. The appellant is appearing by video. Ms. Healy. Mr. Curtin is here. Ms. Healy, good morning. Can you hear us okay?
Good morning. Yes, Your Honor, I can.
And we can hear you and see you just fine. We're all set. We're ready for your argument.
Thank you very much, Your Honor. Harmony Healy on behalf of the people. I discussed the issue of due diligence very, I think, extensively in my brief, but I would just note that under this court's recent decision in Flowers, that knocks out one of the court's issues as to the DNA testing that was performed on February 23rd, because that was after the filing of the initial COC. And so that leaves 6 items that were sufficient in the initial COC. Some of those items, just a very brief list of them. There was there were photographs of the crime scene, a screenshot of a text message from a control car, and a vehicle report.
Ms. Healy, I'm sorry, just for me, would you slow down just a little bit with the video and the audio? It makes it a little difficult, at least for me. But as I understand your argument right now, what you're going through are the items that the court went through on the record. I think there were a total of 10, and yet the court found, if I have the case correctly, 7
The court found
violated.
7, correct.
And
Yes,
no,
Your Honor.
I'm talking over you, forgive me. But I think you were addressing those 7, am I correct?
Correct, Your Honor.
Okay, go right ahead, thank you.
Okay, I'm sorry. So addressing those 7, I just indicated that one of the 7 items was DNA, a data pack as it related to testing that occurred after the initial COC was filed. So that leaves only 6 items that the court indicated were not in the initial COC. One of the items was actually disclosed, and that was found after going back and reviewing the evidence that was disclosed in the initial COC, as well as what was later disclosed when the trial ADA sort of went back over and did an overhaul of all of the discovery. So that left 6, and there was 1 that was disclosed. So now you're at 5 items that were deficient from the initial COC. Of those items, there were 3 things that were in the police file. There were pictures of the van, which was where the rape occurred. And then there was also a screenshot of a text message that was taken by the victim during a control call. Those pictures of the van were actually taken by a civilian photographer, and there was a special method that had to be done to get those photographs in both, I think, the police file as well as in the prosecutor's possession. When the initial trial prosecutor that was assigned to the case, ADA Romer, when she first got the case, they had done 6 conferences with Detective Ruffin to make sure that they had everything that was in the police file, and it was indicated to them that they did have everything that was in the police file. They had also sent multiple letters requesting any and all documentation. And this particular ADA Romer just wasn't aware that there was a special process by which she had to go through and request the photographs from the civilian photographer. And so she didn't know that they existed. It wasn't found that they actually existed until the new trial attorney came on, who has quite a bit of experience in these kinds of cases, and realized that there were no photos, and double checked to see if they were still in the possession of the civilian photographer, whether they were in the possession of the police.
Ms. Healy, real quick, I'm sorry to interrupt you again, but I just
okay.
directed to my question. The way I've counted it, it looks to me, and I think you said this, there are basically 5 chunks or categories of information that have been found to be in the possession of the people when they filed their initial CLC. And that's really the issue that you've got in this case. And you're trying to explain away, so to speak, the reasonableness or the diligence with respect to what was done with respect to those 5 categories of information. But when you compare this case to Mitchell, now, albeit it was a split decision, but the majority carried the day there. And there, I think it was essentially the criminal histories of the victim. Here, there's a lot more that existed, was in the people's possession, and were not produced. I mean, how do you deal with Mitchell?
So I think in Mitchell, there were items that were those items, what Mitchell said, they went directly to the heart of the case because pretty much the entire case in Mitchell was the victim's testimony, and the victim was found to have those two certificates of conviction which weren't disclosed. Here, I don't really think that any of these items go to the heart of the case. There was voluminous discovery that was disclosed, and that's one of the things that obviously they and the line of cases coming from your court indicate are, that you have to consider in terms of factors. And one of them is the voluminousness of the discovery. The discovery that was turned over, there were 97 pieces of discovery disclosed in the initial COC. There's 911 calls, body-worn camera, other criminal histories. There were originally 2 different rapes that were charged. One of them ended up getting dismissed later down the line. There was controlled calls. There were 97 pieces and I think thousands of pages of different things. And the important stuff, the stuff that you would need as a prosecutor to do to try your case, that stuff was disclosed. The stuff that wasn't disclosed were just sort of things that I don't think were obvious to the trial prosecutor. And I think that they also, I guess I would argue that I don't know necessarily that the pictures of the van, that they were in the possession of the people, because they weren't in the possession of the police department. They were in the possession of the civilian witness, and the prosecutor just didn't know that that was a separate step that she had to take to get there. And so the DNA notes, the DNA reports were disclosed. It was just simply the notes that were going along with that and the proficiency test of one of the, I think she was the serologist in this case. So there was quite a bit of medical records, DNA evidence, and all of that came through in the initial COC. And there was also diligence exercised to get everything in the file into our hands, and it just didn't exactly come out that way.
Ms. Healy, why don't you take us to what I would call the alternative argument, that if we find that Bay was not complied with or the statute was violated vis-a-vis the initial disclosure of the initial COC, what's your argument with respect to the alternative?
In terms of the excludable time
counting the time.
Counting the time.
If I recall correctly, and I sometimes get my cases confused, but I think this is the case where the court essentially said, well, now that I've stricken the COC is improper and found that the statement of readiness was illusory, you don't have to count the time. And that's the alternative argument I'm asking you to address now.
Okay, thank you, Your Honor. Yes, so from the reading of the record, the trial judge said that there was no excludable time whatsoever because the statement of readiness was deemed to be illusory. And I think that this court has found in a couple, actually, I think 4 cases that I cited in my brief, that excludable time does apply in the context of this analysis. And there was quite a bit of time, almost all of the time was devoted to pretrial motions, the people's response to motions, made at the request of defense counsel to file further motions, and the court coming to a decision on the motions. And I would argue that under your case law and under 3030 for that time should be excluded, and no calculation was done whatsoever by the trial court.
Okay, thank you very much.
Thank you.
I think we're all set.
Okay, thank you. Have a great day.
Good morning. May it please the court, Paul Curtin on behalf of Lewis Harris. If I may, the people were never ready for trial in this matter, as evidenced by the fact that they needed to submit 5 supplementary certificates of compliance. Those certificates were significant. They included information that were in the people's possession well before indictment. The court gave them 4 opportunities on the record to explain why that information was late. They declined to take up that invitation. Furthermore, they, at no point in any of the supplementary certificates was there any statement explaining why they were late with this information. That in and of itself is worrisome. But then to have a post facto discussion where we're trying to explain it now, I think is not what the statute requires.
Mr. Curtin, if I can ask, what about our Justice Presiding's question about excludable time?
So the court does make a statement where there is no excludable time. However, the defense did submit their calculation of time, and in our reading of that, the people were well beyond 6 months in terms of excludable time. Indeed, some of the supplementary certificates came in well after the 6-month period had passed. So we would submit that the defense counsel's submission of a time calculation should be taken into account by this court.
And the people did so as well. They did a
Correct.
separate calculation as well. So that's presented in the record for us.
Yes, Judge.
To look at. So this is how I interpret it, but don't let me put words in your mouth, okay? But even if the court made an error with respect to concluding that it didn't have to count the time, you would still say there's enough chargeable time to dismiss?
Yes, Judge. I would also like to just quickly address a couple of the items. To say that we're able to parse what was in the supplemental certificates into what was useful, relevant, irrelevant, is to ignore the fact that we had a defense counsel who was days before trial being handed new evidence. One of the supplemental was the day before trial. I believe one was the morning of trial. Even if that information was all irrelevant, defense counsel had to go through it and verify whether or not it was valid or not. It was almost like they were piling on at the last minute. 3 of the supplemental certificates came after the original trial date. So I think there's a real issue of a lack of due diligence, even in failing to explain why these things were late. I would also like to point out one issue, if I may. In the people's reply brief, they mention that defense rejects the holding in Cooperman, and that is not true. Cooperman and Bay both were decided after the decision in this case. Nonetheless, we feel that it was clearly the court's comprehensive and holistic approach to this that led to their decision, and it is very much in keeping with Cooperman and Bay. I believe, unless the court has any other questions for me, that we can then rest on our papers.
I think we're all set, Counselor. Thank you.
Thank you very much.
Moving next to People versus Rodriguez, case number 171. The appellant, Mr. Rosenberg, is by video. And Ms. Denman Wright is here. Mr. Rosenberg, good morning, sir. Can you hear us okay? You can unmute because I think you're first up. So we're ready to hear your argument.
Can you hear me?
We can, thank you.
This is I'm Jonathan Rosenberg, and I represent the appellant, Anthony Rodriguez, who was sentenced to consecutive terms of 25 years on a murder conviction and other felony charges based on shared intent theory, because while he was in the vehicle at the time that another individual who he didn't see what was going on committed the actual murder of this young man. There was this fill-in-the-gaps prosecution in this case, and I just want to jump from the sentencing, go right to the very end of the case to give the court an idea of even what the lower court found when it vindictively sentenced Mr. Rodriguez on these charges. And during sentencing, when the court was admonishing the defendant, they said, "Person that you said was the killer of a 12-year-old boy walked out of my courtroom because he was found not guilty because the jury never heard that critical testimony that you refused to give. That shooting of this 12-year-old boy may well have been an accident, a mistake. I actually have little doubt about that. But what you later did was no mistake. It was as calculated as it was cold." But even the lower court is vindictive in the sense that had you been a cooperating witness in this case, the other guy who's the real shooter, who we all know is the real shooter, wouldn't have been able to walk away from this case. And the only reason you're going to be sitting in jail for life is because, and the judge says, look, even I think this may have been an accident. Even I think this might have been a mistake. Nobody intended to shoot this young man, but we're gonna make you hold the bag for this conviction. And reading the case, it's a circumstantial case, and the judge's comments are correct. This is a case where the judge denied a circumstantial evidence charge. One of the primary arguments in our brief that should have been given the fact it was a case of the prosecution filling in the gaps based on conversations that were very equivocal from the witnesses in the case. There was, for example, a terminology we would hear, the jury would hear about airing things out, or they're going to air things out. And allegedly, Anthony Rodriguez was part of this conversation as a witness that somebody overheard, but it's not clear. It's contrary to my opposing counsel's view in his respondent's brief. It's not clear that Rodriguez made any comments about airing anything out or actually actively talked about it in any way of being involved in any planned retaliation or violence. He was kind of the idiot sitting around, just kind of following the idiots around who were the sociopaths who wanted to, for whatever reason, do what they were planning to do. Obviously, he never should have been in the vehicle. Obviously, he never should have been dealing weed on a stoop. And obviously, he should not have been hanging around these people. But to say that he had shared intent is a stretch and was insufficient in this case. And was also, we asked the court against the weight of the evidence. The prosecution emphasized, and I want to correct it, airing it out. That comment alone and the overhearing of that phrase without actively participating in the conversation created sufficient context for the jury to find a shared intent. There was no dispute in this case. Mr. Rodriguez didn't even have a firearm, though he was convicted of the weapon's possession. There's no evidence that he ever had any DNA or was near any gun. However, the judge, the lower court...
Counsel, let me interrupt you for just one moment here. There is evidence that he knew there was a gun. He had seen the gun.
Yeah, he did see the gun. That's correct.
He was aware there was a gun, and then there was a conversation about going in to air it out.
Justice Del Conte, that's 100% correct. So he saw a gun in a guy's waistband well before any crime occurred and before getting on a vehicle and whatever, this is a...
And he observed a conversation with the man with the gun talking about airing it out.
I agree with that. He did observe that conversation. It would seem the evidence points to that based on what at least one of the eyewitnesses had stated. But just the words airing it out without him being involved in that in any way that we can substantiate is a pretty huge leap to say he shared any intent. In fact, they even credit the officer who testified about his interview with Mr. Rodriguez, even credits him about the fact that he seemed to genuinely think he'd been shot or somebody had been shooting at him when he was in the car, showing he did not expect gunshots or any kind of gun violence. Again, it seems like the reckless decisions of this young man who had, as we saw, these 2 misdemeanor convictions and was clearly a kid who had some problems and had some mental health issues, but was not somebody who was known for violence or planning violence, to give him consecutive 25 years on a case where even the judge says, I think this was an accident. Well, I think the jury could have thought so too, if the judge thought so, and they couldn't have thought it was a murder. You really have to massage that charge and take away circumstantial evidence to get to the point of this individual had a shared intent to commit a crime and to fill in the gap of somehow he's involved in handing off a gun, which the judge implies at sentencing. That's not part of any reality we identify in the record or outside any kind of record. It's just...
Counselor, can you address the issue concerning whether or not the lower court erred in not giving the circumstantial evidence charge to the jury?
Yes, Your Honor. And this was the fatal error on the law in the case. The trial court's refusal to give that charge was fundamental. The entire case was on intent, about shared intent, and that was a central issue, and it was circumstantial, meaning not direct proof. The prosecution presented no direct evidence of Mr. Rodriguez's knowledge or intent in this case. They were at best acts from which the jury had to infer a state of mind. As the judge supported in his own statements at sentencing, who got to see the whole trial, as supported in, I think it's People v. Hardy, I brushed up on the case as the best my memory could. I think a defendant's statement is direct evidence only if it's a relevant admission of guilt. And here, his actions nor statements do not speak to anything that would allow the jury to infer that what Johanna and Alberto had done or planned, as even the court acknowledged, were people primarily involved, had anything to do with Anthony Rodriguez. Unless there are further questions, I would rest on my briefs in this case and ask the court to reverse this conviction because it was a wrongful conviction and grant either a new trial or dismiss the indictment for insufficiency. Alternatively, to modify the sentence significantly in the interest of justice, as this court may. And I appreciate the court's time, unless there are questions.
Thank you, Mr. Rosenberg. We'll hear from the respondent.
Thank you.
Thank you, Your Honors. Elizabeth Dannon for the people. We would represent that there is legally sufficient evidence and that the convictions were supported by the weight of the evidence. Critically, in cases where this court has found that there was not sufficient legal evidence, that there was a shared intent in terms for purposes of murder and criminal possession of a weapon, there was no evidence that, as in People v. Hawkins, there was no evidence that the defendant and the co-defendant were together earlier on the day of the shooting. No evidence that the defendant had prior knowledge, either of that the co-defendant would be armed or they was intending to shoot someone, and no evidence that the defendant and the co-defendant had an ongoing relationship. Here, very ample evidence was presented of all of those aspects, Your Honors. There was evidence that Alberto, the individual that had the original dispute with the intended target of the murder, had been around, that they had been together, that defendant viewed him as a brother, and that they had been in contact all that day. That he had come to the home where defendant was selling weed, and that they had discussed, and that he'd gone to the hospital, and that he came back after going to the hospital. They were seen together, and then so the defendant knew, and he essentially, he admitted to police in his third interview that he had heard this discussion of airing out and that he'd actually participated. He attributed it to a third party who he later identified as himself, that they had had a discussion regarding airing out John Street, which he knew to be in relation to the killing, to Yada, the individual with whom Alberto had the dispute regarding the missing gun and who had broken Alberto's jaw. And there is ample evidence that Alberto had, he had been following, he had tried to run over the intended victim earlier in that day. As was pointed out and admitted by the defense counsel here, the defendant knew that Pizarro was armed. He was aware of the fact that they had been discussing airing out the area, and then immediately afterwards he took the co-defendant to the area right directly behind a shortcut to John Street, where the airing out that was just discussed beforehand was to occur, and that the... For
the sufficiency and the weight, as you're doing
Yes.
now, you're kind of walking us through the before, during, and after.
Yes.
You know, the prior incident with the purported victim, the person they remember to go shoot, the driving, the airing the out, the, you know, we aired it out. So you've walked us through that. Can you take us, if you don't mind, to the second issue?
Of the circumstantial
evidence charge?
Yes, Your Honor. I tried to look through that in my brief. I thought that was a very interesting argument, and I hope that it was clear from my discussion of it. I had looked into that. The Court of Appeals had stated that where the you can't infer from the facts argued.
It has to be direct evidence would be an admission of guilt, as opposed to statements from which inferences are made.
Yes, and
that's the Hardy case, which is based on Burke, I think, and Hardy seems to be what the defendant relies on here with respect to the evidence, the statements from the defendant not being direct admissions of guilt, that is, I shared the intent, I knew what was going on, but were rather statements that could provide an inference. That's the issue, and I think in your brief you even say something to the effect of, it's an interesting issue, or you don't say close call, but you make the representation that, yeah, this is complicated.
Well, Your Honor, I do believe that his admissions constitute everything, prima facie case for the crime. You just have to add intent. And there's case law that says you do not have to, it says, a circumstantial evidence charge is not required merely because the proof with respect to any particular element, here intent, is wholly circumstantial. That is a case, People v. Reynolds, out of this department in 2000, 26980, 2D735. And here, that's the only element that would have had to be established by circumstantial
Counselor,
evidence. Yes.
let me see if I can break this down.
Yes.
In my mind. The defendant is charged and convicted with murder and possession of a fire.
Yes.
And the circumstantial evidence contention, as I see it, is addressing the murder conviction. That the defendant's contention is you got to make some leaps. You got to, from the conversation about airing it out to what ultimately happens, you have to connect some dots. Well, what about the possession of a weapon? The defendant in this case saw the gun.
Yes.
Knew there was a gun, gets in the vehicle with the guy with the gun.
Yes.
Is that direct evidence of CPW2?
Yes, Your Honor. I did attempt to address that in the point regarding sufficiency and weight of the evidence. With respect to the fact that there was evidence that the defendant and the co-defendant were together earlier in the day, that they had prior knowledge that he would be armed, was intending to shoot someone, and that they had an ongoing relationship. All of those were brought about. They had prior familiarity. They knew that there was, he was.
So what do we do then with this contention that the evidence connecting the defendant to the murder as an accomplice relies on this circumstantial evidence question, but maybe not on the other charge?
I guess, Your Honor, I would, my position was that the intent element could be established circumstantially. I thought it was, and it didn't, and that didn't necessitate a circumstantial evidence charge, but I believe it was established adequately through the evidence that was produced
For the murder charge?
For the murder charge and for the criminal possession of the weapons
Right.
charge, Your Honor. So that would be my position. With respect to prosecutorial, with the sentencing, we would just state that it was not, he was not punished for his going to trial, Your Honor. It was it was because he reneged on his promise to, he put the interest of the co-defendant ahead of his ahead of justice. He
Santa, your opponent says that the judge's comments were rather vindictive in that regard because of the fact that you failed to abide by your agreement. The actual shooter walked out of the courtroom.
Well, Your Honor, I think it does.
Are those claims appropriate?
Well,
a little harsh.
I think it was pretty well established that he did, allow the other individual, the actual shooter, to go free. I do believe it was within the sentence range. He did. There was a murder and an attempted murder, and.
There's no dispute that
Yes.
it was a legal sentence.
Yes, it was a legal sentence, Your Honor.
Maybe a little.
Perhaps.
Perhaps. Yes.
Thank
Thank you very much, Ms. Dana. Good to see you again.
Thank you very much. Next case for argument is 172, People versus Cooper.
Good morning, Your Honor.
We should have counsel for the respondent here by video in a second. With any luck, Mr. Kemp. Mr. Marty, good morning. We can see you. Can you hear us? You'll have to unmute so we get your response.
Good morning.
Can you hear us?
Ray Marti for the People.
Perfect. We're all set to go. Mr. Kemp, ready to
Good
go?
morning, Your Honors. Robert Kemp on behalf of Deshaun Cooper. May it please the court. Mr. Cooper maintains that any alleged or claimed abandonment of property was a coerced and provoked reaction to the illegal police activity and thus warrants suppression.
How was it coerced?
Well, luckily we have the video of Officer DiAgostino's body cam footage that shows the whole events as they unfolded. The police
I
had.
see Mr. Cooper exiting the vehicle and running away.
Yes, they do. So if I could just.
How is that coerced?
Not to belabor the facts here, but they had the two 911 calls of the alleged suspect that matched the description. It was Deshaun McCutcheon, I believe his name was.
You don't dispute that.
So there's no dispute that, and there was no call of the white vehicle that it was, and it wasn't legally parked. There was no description of any other suspects.
Well, I guess the description, wasn't it, of Mr. McCutcheon?
Mr. McCutcheon.
So they saw Mr. McCutcheon standing next to
Yes.
the white vehicle. I mean, the original call wasn't in relationship to the Mr. McCutcheon hanging around a white vehicle. It was
Correct.
him brandishing a weapon.
Correct. There was no description of the vehicle or any other suspect. So the other occupant of the vehicle was Nick Davis. He exits the vehicle, not to belabor the point.
He's the driver.
He's the driver, and immediately Officer DiAgostino tells his partner to grab Davis for no apparent reason. There was no reason whatsoever to grab Mr. Davis, and that caused Mr. Davis to flee. So the front door, the front passenger door is open, the front driver's side door is open. And it's unclear whether Mr. Cooper's in the back seat or the front seat. It's really unclear from the video.
He's in the back seat, you can tell, right?
Well, I don't know if you could tell. I viewed this video numerous times. It's very, because the windows are dark.
His leg comes over, you can see that.
So, okay,
You can see him in the rearview mirror, exactly, you know, and then he's got a piece of yellow in his pocket or in the back, something like that. You can see that coming over the seat and then take off.
So he's in the back seat of the vehicle.
Right.
The police tell the other, DiAgostino tells his partner to grab Davis for no apparent reason. So then Mr. Cooper flees. He has no reason to, he's not engaged in any criminal activity.
That's how he was coerced?
I think that's how he's coerced. He hears the police officer tell his partner to grab Davis. There's no reason to grab Davis. There's no reason even to grab Mr. Cooper, but he feels that he's going to be harassed once again by the police. God knows how many times he's been harassed by the police, so he flees the vehicle. There's no reason for him. He has every right to flee the vehicle. It's unwarranted police activity.
The pursuit was improper.
Correct. So there's no reason to grab Mr.
So he left the gun behind.
Allegedly, that's what they're alleged.
So for example, if he had the gun on him when he jumped over the front seat and exited the vehicle and fled, and the officers apprehended him, are you saying that in that situation?
That's a different fact.
That's a different situation, and that gun arguably would be suppressible.
That's a different fact pattern. The
Right.
911 calls were of Mr. McCutcheon waving a gun around. They had no reason to believe anybody else was involved with this situation. So DiAgostino even testified that they were going to apprehend anybody regardless of any criminal activity that was apparent here. So, and DiAgostino said, he testified several times that he
I guess it
saw...
all comes down to whether or not the weapon was abandoned by Mr. Cooper.
That's correct.
Why don't you address that?
And I believe it's just provoked and coerced by DiAgostino and his reaction of telling his partner to grab Davis, and he was going to grab... He admitted on the stand that he was going to grab Mr. Cooper, that they were going to chase Mr. Cooper and seize him because they believed anybody who fled would be guilty. So that's the testimony of Mr. DiAgostino, that they were going to apprehend anybody. And he even testified that he saw the gun even before Mr. Cooper left, and that's belied by the body cam.
There's a question of whether or not Mr. Cooper has standing to make this comment.
That's correct. And the court did...
But below, he was just challenging the fact that he was pursued by...
That's correct.
He didn't address the privacy issue below.
I think the court acknowledged standing, as I recall.
Well, they acknowledged he did not have standing.
I'm sorry?
The court below said he did not have standing.
I do not recall that. I just remember that the court said that the police didn't engage in any illegal activity.
There was no evidence by Mr. Cooper that he had a right to privacy or expectation of privacy.
Well, he was in the vehicle.
Right.
So he has an expectation of a passenger in that vehicle.
But he left.
He left because he was provoked and precipitated by the illegal activities of the police. Thank you.
Mr. Marty, all set, sir.
May it please the court, Jerry Marti for the people. The central issue here is whether the defendant intentionally abandoned the gun. And part of the language in the Boodle Court of Appeals was the defendant's actions a direct and immediate response to the police conduct, or was it an independent act? Here it was an independent act because there was no police direct interaction with the defendant while he was in the vehicle. The defendant brings up the fact that they approached Davis. Now, a couple of considerations there. Still, there's no direct interaction with the defendant. Davis had just moments earlier exited the vehicle and pointed at the defendant while he was inside and telling the police he had nothing. The police had a right to be there because they had a right to approach the suspect who made an earlier call. If you look at the facts of Boodle, they're even more egregious than they are here. In that case, they stopped the defendant who was on 125th Street in New York City and told him to get into the car. While they're in the car with the police officers, they ask him, "Are you clean? Do you have a weapon on you?" And not more than 5 seconds later, he throws the gun outside the window. The court there said it wasn't a direct and immediate response to the police conduct. Based on those facts, here, there was absolutely no conduct. They didn't force their way into the car. They didn't question the defendant. And I think it was an independent act. Last thing I'd like to just point out, the plaintiff's case, the defendant points out to a number of cases that actually support the people's position. They point out to cases in which the defendant is the police are in direct pursuit of the defendant when the defendant discards the weapon. They even point out a case where he's tackled. Those aren't the facts here, and those cases actually help the people's position. So based on those facts and deference owed to the hearing court, I would ask the court to affirm the lower court's decision. Unless there's any other questions, I'll rest on the remainder of my brief.
We're all set, sir. Thank you.
The standing, wait just a minute, I'd like you to address the standing issue.
Yes, Your Honor. The lower court found there was no standing because there was no reasonable expectation of privacy. The defendant had abandoned the gun.
And the court made that finding. In fact, I'm looking now at the appendix at pages 120, 121. That was the initial finding that the defendant lacked standing right there, correct?
Yes, Your Honor.
I think we're all set. Thank you.
Thank you, Your Honor.
Calling now case number 173, Candy R.J. versus Oswego County et al. Justice Del Conte is recused, and we have both counsel, I think, will be appearing by video.
Because no one can get out of Oswego?
What's that?
Because no one can get out of Oswego.
Yeah, right. Okay. Mr. Merblestein, could you hear us okay?
Yes, I can. Can you hear me?
We can. Ms. Watson, can you hear us okay?
Yes.
Okay, so I think we're ready for your argument.
Thank you. May it please the court, Stuart Mermelstein for plaintiff appellant CRJ. I'd like to begin with the question of whether parties are united in interest under CPLR 203. And the parties at issue here are the county, Oswego County, that's responsible for the custody of the plaintiff foster child in foster care, and a contract agency, Berkshire, which was assigned to perform the custodial duties of the county in this case. There have, in the briefs, there's much discussion regarding the case of Weiss Broadmoor versus Cayuga County. And in that case, this court had determined that there was no special duty owed by a county to a child in foster care. That decision was reversed by the Court of Appeals yesterday.
Just a few days ago, right? Yesterday. Yes, that was reversed yesterday.
Yesterday it was reversed, yes. And in that decision, the Court of Appeals declared that that where there is custody of a child in foster care, that gives rise to liability for the county for the negligent supervision or placement of the child. So given that, it opens the door, certainly in this case, for the issue of vicarious liability, which is alleged in the plaintiff's Second Amendment complaint against Berkshire, and it's also alleged by Oswego County in its third-party complaint against Berkshire.
So, Counselor, real quick, I think I'm following your argument. Just piece it together better for me. So, Wise Read More, I read the decision yesterday. Are you saying that it helps your argument on the united in interest concept?
Yes.
And how is that exactly?
Well, there's cases that say that essentially that vicarious liability equals united in interest. So if one party is vicariously liable for the negligence of the other, then the two parties are liable for the exact same acts and omissions. In that event, they're united in interest. And the case is fairly well established that. So in this case, the municipality, Oswego County, was in custody. That's shown from the facts in the record. And there's an agency involved, Berkshire, which, again, the plaintiff found out, parties found out long after, or well after, almost a couple of years after the
So then what,
should be brought.
can I redirect you for a minute? Can you go into why doesn't the statute of limitations apply in this case to Berkshire?
Well, under the CPLR 203C, it essentially provides that the filing against one co-defendant is filing against the other co-defendant when the two parties are united in interest.
Right, okay, except for they need some notice of this, correct? That they are united.
Right, well, the notice is provided through the filing and service against the co-defendant. That's notice to the united in interest new defendant that is added into the case. That's the theory of CPLR 203, and that the three elements of CPLR 203 relation back make it clear that under that theory you can bring in a new defendant, and so long as they're united in interest, it is the filing and service on defendant one.
Wouldn't Berkshire have to be aware that there was an action that had been commenced against the county? Is there any?
And that is not the case. That is not the case by the plain language of CPLR 203C. And if you look at the cases on this issue, for example, the hate case cited in our papers in the Fourth Department, that case, looked at the question whether that examined the third element of CPLR 203 relation back.
That's what I'd like you to concentrate on.
I'm sorry?
That's what I want you to concentrate on, is that third element.
Okay, that's fine. And under the hate case, the court looked to the underlying facts, the records that were in the case. And this issue often comes up in medical malpractice. And the idea was that where the defendant would know from the medical records that it was had provided treatment care, was responsible party, then that is sufficient under the third element to show that but for a mistake by the plaintiff as to the identity of the proper parties, the action would have been brought against the new defendant. And that is the case here in the foster care contracting situation. Plaintiff had no idea that Berkshire was involved, was a contracting agency, and then found out during the course of discovery and investigation in this lawsuit, and the records ultimately obtained from family court establish that or demonstrate that Berkshire was a party involved. So the elements of the third requirement are that in not suing the defendant, the plaintiff made a mistake and was not employing a strategy to obtain a tactical advantage, and was not engaging in any gamemanship or manipulation.
Well, isn't the
case here?
Counselor, isn't the primary question whether the added party had actual notice of the claim? Isn't that aren't they talking about the linchpin?
Yes, but the linchpin of notice is whether that party would know from the records, from the underlying facts, that it was involved in.
But if they had no idea that anything had been brought forward, how are they supposed to know that?
And that's because their united in interest co-defendant had been sued. They're charged.
But they were not aware that they were sued until August 22nd, 2022, which was over 9 months after the expiration of the limitations period. Correct?
That, yes, before the Berkshire was brought into the case. But
they weren't aware that the county had been sued.
Yeah, my point is that the new defendant does not have to be aware of the complaint of the suit that was filed prior to the expiration of the statute of limitation. The third party has to be aware of its involvement, has to be aware that it would be an intended defendant if it had been sued. And that's what the cases stand for. If you look again, this court's decision in Haight, that's what is demonstrated.
And when, Counselor, exactly do you say that occurred?
That when the complaint was filed against Oswego County.
No, I know your argument, and maybe I'm behind, forgive me. Your argument is that it's not when the complaint was filed, it's when Berkshire knew of the claim, if I understood your argument correctly. And if that's correct, then my question is, when did that happen?
Let me restate the argument. Berkshire, I don't know when Berkshire knew of the claim. We don't have any facts at this point to show that Berkshire knew of the complaint prior to the expiration of the CBA, or when the complaint was originally filed. We haven't. This was a dismissal, but we don't have the benefit of any discovery on the point. But my point is that under CPR 203, the plain language, the structure of the rule is that at the time that you file against defendant 1, you have given notice to defendant 2 by virtue of the fact that those two parties are united in interest. So
you're basically, let me paraphrase it this way, if you don't agree, please let me know. But you're saying that in this situation, satisfying prong 2 satisfies prong 3. If that's the case, why is there a prong 3?
I'm not saying prong 2 satisfies prong 3, because prong 3 examines whether first of all, it has to be a mistake. If the plaintiff is aware of the new defendant 2, at the time it files the complaint and doesn't sue them, well, that's the plaintiff's problem. But that's not the case here. And prong 3, the third element, looks to whether or not is the reason that this defendant wasn't added a matter of strategy, tactical advantage, gamesmanship, some effort to take an unfair advantage by the plaintiff. And it's certainly not the case here. The fact, and the lower court said so. The plaintiff could not have been expected to know about Berkshire at the time it brought suit and commenced this action as against Oswego County. But the theory of liability is like asserted is vicarious liability, and that establishes united in interest. So you have the second element. The third element is that the plaintiff didn't know about this defendant, this new defendant, and has no intent to, was not engaging in any strategy and not suing the new defendant, because certainly it didn't know about the new defendant.
Counselor, I know we've taken up a lot of your time with our questions, but at some point I'm going to ask you to wrap up fairly soon, so I want to give you some time.
Thank you. Again, I just want to emphasize the point is that the language of CPLR 203, particularly 203C, which sets out the united in interest element, makes clear that the notice required is the notice to defendant 1. And that you can add defendant 2 when they're united in interest. And so long as the plaintiff didn't know about defendant 2 and isn't manipulating the system, then that defendant can be added, as long as you have the 3 elements. And we have shown in our briefs that the 3 elements are present here. If there are any further questions, I'll rest on my briefs.
Great, thank you. Before respondent argues, just one thought comes to mind, and we're not requiring it. But one thought is, given the recency of Weisbrod Moore coming out yesterday, if the parties wish to seek to file a post-argument submission, it might be a good case for that. I can't predict it exactly, but just one thought in case both parties want to address the impact of that case here, that might be a good idea, but I'll leave that to your judgment. With that, let's hear the argument from the respondent, please.
Thank you, Your Honor. Bonnie Watson for defendant, respondent, Berkshire Farm Center and Services for Youth. May it please the court. Originally, plaintiff sued only Oswego County and does 1 through 10 in this case. 2 years after the statute of limitations for CVA cases expired, the county took the initiative to bring Berkshire Farm in as a third-party defendant, and only at that point did plaintiff assert a direct claim against Berkshire Farm. Her initial attempt was obviously to rely on CPLR 1024 in her amended complaint against Berkshire Farm. Doe 1 has disappeared, and Berkshire Farm is now a defendant with a separate claim asserted against it, and Does 2 through 10 still in the complaint. But at this point, I believe the plaintiff has realized that there's no basis to rely on relation back on, who rely on CPLR 1024 relation back, and after the fact, she is attempting to rely on 203, but she also does not meet this test. Really, the only type of relation back that does apply here is the principle that a direct claim against a third-party defendant relates back to the date that that defendant was brought in by the primary defendant, and here that was in 2023, well after the statute of limitations had expired. I'm sorry, I was getting background audio. I would like to focus. I would like to focus primarily on the third element, the notice element of the CPLR 203 relation back doctrine. Plaintiff's argument essentially conflates the second and third elements, saying that if there's unity of interest, then the first named defendant's notice can be imputed to the new defendant.
And it's clear that that's not so. It can't be imputed. You have to have some actual notice, correct?
Correct. Yes, that's absolutely not the case. This would not be a 3-element test if unity of interest automatically satisfied the notice element. And the case law is abundantly clear that this third element of notice is a separate and distinct element that can be not met, even if unity of interest were met.
And again, in this case, the record's devoid of any evidence that Berkshire was aware that this action had been commenced against the county prior to the expiration, correct? Correct.
And I do want to briefly point out on the evidence issue, this is not a 3211A7 motion for failure to state a claim. It's 3211A5 motion, which brings up a statute of limitations defense on this type of motion to dismiss, the plaintiff does have an evidentiary burden to establish that an exception to the statute of limitations applies. And the plaintiff actually just admitted they have no facts of when Berkshire learned of this claim. If discovery were done on this issue, it would be established that Berkshire learned of the claim in 2023 when Oswego County sued it. It had no idea in 2021 that Oswego had been sued. There was no actual notice, and the fact that the county had been sued can't be imputed back to Berkshire Farm. The Court of Appeals in the Baran v. Kupal case was absolutely clear that notice is the linchpin of the third element, and that the nature of a mistake that may or may not have been made by plaintiff is secondary. There are many cases considering notice and finding that even the defendant one's notice is not imputed to defendant two, that the plaintiff has the burden of showing that defendant two knew about the case within the original limitations period and should have known, based on what they knew about the case, that they were meant to have been a party, essentially. There is no evidence that Berkshire knew. We do also address in our briefing that under the particular facts of this case, had it known, there's still doubts over whether it should have known it was a defendant, intended defendant. But the bottom line is that there was no actual notice. All the other elements of this test don't even matter. There cannot be relation back.
So the linchpin of your argument is notice.
Yes.
Okay.
Well, that's the primary linchpin. As far as if you were to get past the notice issue and consider whether, suppose that Berkshire Farm somehow knew of the existence of this case during the limitations period back in 2021. This is also a case where it could not have had constructive notice that it was an intended defendant, because looking at the complaint, all you see is a set of initials and an allegation that the plaintiff was injured 4 years before Berkshire Farm began providing services in Oswego County. There's no way that Berkshire Farm, looking at a complaint like this, should have known that the plaintiff couldn't remember whether her abuse happened when she was 11 or when she was 15, got the date wrong in the complaint, and meant to make allegations about a potentially a placement that potentially Berkshire Farm had some involvement in. So for that secondary reason, also the third element is not met. As far as unity of interest, the plaintiff, as I also discovered the Wise Broad decision yesterday, ultimately it doesn't affect our arguments all that much, as we prefaced somewhat in our opposition brief well before the decision came out. If Wise Broad had been affirmed, that would be dispositive, because there cannot be unity of interest if one of the parties cannot be subject to liability at all. But ultimately, it doesn't change the analysis much, because all that Wise Broad found, or all that the Court of Appeals decision yesterday in Wise Broad found, is that a county has an actionable duty. It did not find that a county has a non-delegable duty, and therefore it did not answer the question of whether a county defendant can be vicariously liable for the actions of the contract service provider. The majority actually, responding to some concerns raised by the dissent in the Court of Appeals decision, went out of its way, this is on page 12 of the slip opinion, to confirm the duty we announced today does not require government employees to take responsibility for harm inflicted by third parties. It also notes that recognition of a duty on the part of municipalities administering foster care systems does not impart strict liability upon the government. The duty that the court found is not at all a non-delegable vicarious liability type duty. It's merely a standard negligence type duty where if multiple parties were involved in allowing an injury to occur, each one is liable only for its own negligence, and that is not a unity of interest relationship. The case law is clear that for unity of interest to apply, the parties have to share precisely the same mutual relationship. And the opposite is true here. The county's liability and Berkshire Farms liability are essentially mutually exclusive. If one of them was supervising the plaintiff, then the other can point the finger at that one and evade responsibility. There is no employer-employee type vicarious liability that would establish unity of interest here. And the first element of the unity of interest is doctrine, or rather the relation back doctrine. Essentially, the fact that there isn't unity of interest answers that element as well, whether the liability arises from the same facts, because neither the county nor Berkshire Farm can be held vicariously liable for an intentional tort by the foster parent, and neither the county nor Berkshire Farm can be held liable for the other defendant's negligence. Each of their liability would have to arise from separate acts or omissions on their own part, and therefore separate facts.
Which ties into what you just argued with respect to non-delegable duty, correct?
Correct. Yes,
Okay.
It is clearly a delegable duty. I don't believe there's any case law specifically on the issue of whether a county can delegate its duty to supervise foster placements to a private entity, but the Court of Appeals decision, Chinani, cited in our brief, is a case where the plaintiffs alleged that a school had a non-delegable duty to provide bus transport, and the Court of Appeals found that the duty was delegable, that the duty to supervise minor school children on their way home could be delegated to a private bus company. And a school's duty to school children is very similar to a county's duty to foster children, which is actually confirmed by the Court of Appeals decision in Wisebroad yesterday, that it has essentially a parental duty of supervision. And if the duty to supervise school children on their way home from school in a bus can be delegated, so can
And Counselor, like I did with the other side, I'm going to kind of ask you to wrap it up here. I think we've got most of our, we've certainly read your brief. Anything further?
No, Your Honor. I think everything else is covered by our brief.
Well, we appreciate your arguments very much. All set. Thank you. Moving next to...
Snowing there? Is it still snowing there?
Moving next to number 174, in the matter of the state of Metz. And I know the respondent has submitted, and the appellant is here.
All right. Good morning, Your Honors.
Good morning. You're all set, sir. Go ahead.
All right. And I realize we have a bit of a laundry list to get through in terms of the issues that we're appealing today. Hopefully this will all bring some finality to...
We would hope that you start with your strongest ones and go from there.
Hopefully we get y'all through, and we can start with, I think, the simplest and most straightforward one is what we mark as issue 2, which is just that this is an accounting. I understand that there are many specific and particular details, and for the most part, I'll direct you to our brief in terms of analyzing and putting together the arithmetic of what goes where. But issue 2 is the simplest one. We believe that there were a number of checks that the lower court did acknowledge were properly chargeable and part of the surcharge that it did levy.
And how much did that amount to? Roughly 58,000 or so? Do we have
58,
the number?
yeah, about 100,000 were already included, and then there were about additional 58,000 that we think the court just overlooked.
These are the 12 cashiers or bank checks that say the remitter is the petitioner, right?
Correct, that the remitter is the petitioner, the payee is just listed as Key Bank. For most of them that were personal checks, the court did grant those as part of our surcharge. There were just a few additional ones we believe just may have been misfiled. One of the broader issues I do want...
Does the record establish the source of those funds? I mean, I'm a little hung up for a second, maybe, on the remitter being the petitioner.
The signatory is the petitioner.
Well, it says remitter at the top of the check for all 12 of them, as I recall it. And then it went to Key Bank. Do we know which account it came from and which account it went to? And does that matter?
We know it came from either the decedent's savings account or checking account. I'm not sure which one. The payee account is unknown because it's not written out and is in this particular way where it's written to the bank. The respondent did admit through his counsel that these were just payments that he gave to himself with no clear
Counsel,
purpose.
as I gather your argument, your position in preparing the account, Mr. Watkins had a duty to report and explain.
Yes.
And while he may have reported the $58,000, there's no explanation as to where that $58,000 went to, except for the reference back to his attorney's email. It says, yeah, that money that went to the Key Bank account, he used, can't explain it.
Yes, no, I believe that's correct.
Yeah, that's your position.
That's our
here.
position, and
And that the court somehow, for whatever reason, that $58,000 was not included in the surcharge.
Right, the court did acknowledge it for
the other
the rest of it, which were
the other
all-
checks that came from the same account looked very
and
similar.
looked in the same pattern, yes. One of the broader issues I wanted to emphasize is just the beginning of the respondent's accounting. He starts in 2010, which roughly coincides with the decedent's injury. However, he was granted the power of attorney in 2007, and while I do understand that in many cases people will sign a power of attorney and it won't be used until incapacity in their, once they're infirm or they fall, in this case he both readily admitted at trial that he did use that power of attorney, that he directed the liquidation of some of her accounts in reliance on that power of attorney, and also in the record we have checks that he signed, documents that he executed on her behalf. So we believe that he should have been required to account for that period, or at least for what he did during that period.
As I understood the argument, and maybe I've got this wrong, but you really weren't looking at 2007. It looked to me like you were looking at 2008, 2009, and you were focusing on the Merrill Lynch close it comment and the one Genworth, I think it's -041 annuity.
Those are the earliest assets that we could identify and catalog and show that he had control over that Merrill Lynch account in 2008. We weren't able to get any earlier statements because they were no longer held by the bank once we were in position to do so. We would have gone back if we could have had information, but...
To Justice Del Conte's point is that even though he did that action, there's no explanation of what happened.
In this case, there's no report of that action either.
Right.
Because the first transactions that he accounts for are in 2010. These in 8 and
Right.
9, we were able to reconstruct, but...
Right. The issue here, I think, is, your point is, in January of 2010, when the accounting begins, the decedent has around $670,000.
In 2010, that's
But if
about
you
right.
back it up 2 years, she's closer to $1 million.
Yes, that's correct.
And so where did that $300,000 go? That's really what you're driving at in all of this.
Right, that we knew that at least as of 2008, she may have been in a different position in 2007. We just were unable to reconstruct it from our discovery. But in 2008, that she was closer to $1 million. We know that there are certainly explanations for some of these transactions.
Right.
But that his duty to account, we believe, began with the first transaction that he executed as her power of attorney. And that's, he admits that was in 2008 or 2007, and that it's missing from his accounting, which doesn't start until 2010. So he will need to account. If he is unable to account, we'll deal with the surcharge. But for now, we just don't know what he did other than what he's admitted to us, because he didn't complete his accounting that far back. A related issue is accounting for her income. Part of this would be in those previous years. We have her total income from her pension and Social Security via her tax returns those years, but those are not included in her account, in the respondent's accounting. So in those cases, it is unclear whether or not, again, to Justice Del Conte's point, report and explain. Explanation is easy. This should be here. We know this is income that should go into her accounts. It is not certain other than an offhand comment that, oh, I put it in those accounts. Well, he doesn't show us. Here are the deposits of her Social Security checks into this account. Here are the deposits of her pension into those accounts. So for years before 2010, those would be missing altogether since the accounting doesn't include those. After 2010 until her death, they're simply not identifiable in his accounting. So we believe that he should be chargeable with those to the extent that he did not adequately show us that I took this money in, it was hers, and I put it here, and you can see it in these statements. One of the more complicated issues that I wanted to bring up, but I think is important here, is the extent to which the respondent, we believe, frustrated the decedent's testamentary scheme, which is to say that when he took over her accounts as her power of attorney, she had a will. She also had a number of these annuities. The annuities all had different beneficiaries in different proportions, admittedly somewhat more complicated than maybe would be ideal, but they were all a little bit different. What he did, as we can see through his record, and as he ultimately ended up with, is when she needed cash, he would liquidate an asset in which he either had no interest or a small interest as a remainder beneficiary. So there is at least one annuity where he was the only beneficiary. He apparently never touched that. Where he had only a small interest.
Wasn't his explanation that was pursuant to the decedent's wishes?
On that point we believe that would have been unclear on whether that was credible. We don't believe that it would be, especially since this was years afterwards. She was already ill at this point, would not have been able to communicate that. And of course it is self-serving and credible. But this would be a point where she was hospitalized, was with an advanced dementia, that she could say, well, make sure that you make sure to protect the Allstate annuity for yourself. And we can see that the proportions of her estate changed dramatically as a result of this.
Counselor, one of your clients is also a co-fiduciary.
Is a separate fiduciary, is a power of attorney,
Power of attorney during this time.
Yes.
And didn't your client maybe have some responsibility here too, some duty to make sure that Watkins was living up to his responsibilities?
She did, to the extent that they were able to get any information from him, they were trying to inquire. But as a power of attorney, she's not a trustee or a guardian.
But the power of attorney, your client.
Yes.
Mr. Pellegrino, I believe, he had the legal authority to go to Merrill Lynch and Genworth and Key Bank and make sure that Mrs. Metz's assets were being used for her benefit, right?
He had the authority to get documents from there, but he was not in a position to be able to. Because he's not in a position of a guardian where he has a fiduciary responsibility for what he does.
That's what Mr. Watkins says here, though, is Mr. Pellegrino had a POA and he didn't do anything. He consented to what I was doing here.
I think consent is not the story here. It's that he did not, we can say that we were not, my clients were not in the position to keep an eye on everything moment by moment, nor did they realize that he was making these transactions.
Because I say that particularly with sort of these discretionary issues. Which annuity do I liquidate, Genworth or the Allstate annuity? And, Watkins was, from Watkins' perspective, making some business judgment calls. I mean, there might have been some different annuity. In addition to who the beneficiaries, there may be some other reasons we want to get out of Genworth.
Mm-hmm.
And your client didn't intervene, do any investigation, exercise any due diligence, even though he, in fact, had an attorney status as attorney in fact.
He may have had the authority, but I do not believe that he had the knowledge that anything was being mishandled, that his aunt appeared to find this man trustworthy, and that whatever suspicions really only came when they were able to do an investigation afterward. But your point is well taken. We do wish that we had been able to notice this and address it earlier.
Well, there's nothing prohibiting him from doing that, correct?
There would not have been, no, at that point. But just that there was no notice. And again, don't want to stress, as a power of attorney, he is not the same as a trustee. He did not take possession. None of the powers of attorneys, in fact, take possession of assets and manage it on behalf of their, the principal in the way that a trustee or guardian would, and actually have that responsibility to manage this is largely to be able to continue to carry out the wishes as already expressed.
So you're saying that Mr. Pellegrino wouldn't have the same fiduciary duty as Mr. Watkins?
Because the fiduciary duty only attaches when you act, rather than, there isn't again, in a way that a trustee has a duty of care for actions that may become necessary. A power of attorney has the authority to act and then is responsible for all of their actions taken under that power of attorney, but does not have the supervisory role that a trustee would to look into every transaction as it happens. And this is why you mentioned initially, Your Honor, that they were co-fiduciaries. I do not quite believe that that is the right explanation for that relationship. The trustees who have to act together, they're sort of simultaneous.
No, I understand, but in this case, it's even more complicated because your client was also serving as attorney to Mr. Watkins in some related litigation.
Yes, and which is a complication, but
fairly significant complication. So one is a client, an attorney, and then they're also co-fiduciaries of this $1.2 million. So we think we.
That's family for you.
Right.
Family business does remain much more complicated.
Right.
But I do understand, but that they had no reason to suspect that he was manipulating these things to the extent that he was. Things seemed all right.
Counselor, any other really critical points that you feel you should make to us in oral argument?
I think on behalf of my profession and our shared profession, I should note that we did request attorney's fees, and that was not addressed by the lower court. I understand it is a discretionary issue for the trial court, but one that they did not seem to take up. We also did request interest, and I think that's adequately explained in our brief. So I believe from there we are happy to rest on our brief. If you have more questions,
We're all set. Thank you.
Thank you, Your Honor.
Calling number 175 on the calendar, Hamilton Equity Group versus Benetatos. And both lawyers are appearing by video.
Good afternoon, Your Honors. Can you hear me?
Don't rush us. It's still morning, Mr. Gomberg. Okay. In any event, we can hear you, sir. Mr. Brasky, can you hear us? And we want to test your mic here.
Yes, I can. Can you hear me?
Yes, we're all set for the argument. I think, Mr. Gomberg, you're up, so go ahead.
Good morning, Your Honors. If it pleases the court, Stanislav Gomberg of Gomberg Legal, PC, for appellant defendant, Maria Benetatos, a.k.a. Maria Valvi. Skipping to the point here, the burden of proof in the Travers hearing that was held rested with the respondent plaintiff. The plaintiff produced the process server, but the process server testified to having no personal knowledge of the service, no recollection of the service. Process server had no notes, no documents in support of the purported service, other than the affidavit of service, which was stamped by the Erie County clerk, was held and maintained by the court, not by the business, not by the process server, and which was an uncertified copy. Only an uncertified copy was proffered to the court. Now, there was no legal basis for receiving the affidavit of service into evidence under the business records exception to the hearsay rule, which is exactly the way that the court erred and did submit and admit the affidavit of service, which was the sole piece of evidence provided by the respondent plaintiff. The reasons for it being improper is that it was specifically prepared in contemplation of litigation. The affidavit of service, there was no foundation that was properly laid, since no testimony was offered to show that the record-keeping practices of the process server or his company, and no procedures of the business.
Counselor, just real quick, the record at page 121 or thereabouts seems to suggest that there was a voir dire by counsel, correct?
Correct.
After that voir dire concluded, did that counsel interpose any objections on the record along the lines that you are now describing?
Your Honor, the basis for the objection was maintained as confirmed by the judge, which was that it was not a business records exception to hearsay.
Okay,
and
go
namely,
ahead. No, go
and
ahead.
the third reason why the business records exception does not work in this case and was an error by the lower court in admitting the affidavit of services The document received into evidence was stored and maintained by the court, not by any business. It was stamped on the top right of the affidavit of service, which is on page 42 of the record. It clearly shows that the county clerk stamped it. How can the witness, the process server, be qualified to admit a document from the county clerk? He's not an employee of the county clerk. The process service company doesn't use a county clerk stamp. There was no evidence or testimony provided to demonstrate that the document was actually held by the business. It was certainly not an original. There was no certified copy of the county clerk's filing proffered to the court. Respondent, in effect, took a stamped copy of the uncertified affidavit of service from the county clerk and tried to pawn it off as a process server's business record. Certainly a bad precedent to hold. Admission of the affidavit of service as a business record was reversible error, which is what we are requesting here today. So to highlight, process server couldn't recall the document whatsoever. He had no personal knowledge. No original was accounted for. No foundation for past recollection recorded was laid. The affidavit of service submitted was stamped by the county clerk, stored and maintained by the court, not the process server or the business, thereby failing to meet the business records exception. And as a result, respondent plaintiff failed to meet their burden. Their burden, since the point of the Travers hearing was that the presumption of service was rebutted by the underlying motion that led to a Travers hearing. As a result, we're respectfully requesting that the order and judgment of the lower court be reversed, case dismissed for lack of personal jurisdiction. And unless there are any other further questions, we will rest on our brief.
We're all set, Counselor. Thank you. Respondent.
Thank you, Judge. The process server at the hearing testified that it was his signature on the affidavit of service, that he had created the affidavit of service in the normal course of his business as a process server. He also offered testimony just about his general business practices in creating these affidavits of service, which is, he goes to the service, he takes notes in his field notes, then he transfers those field notes into his affidavit of service, which is ultimately filed in the case, which is why it has the county clerk's stamp on it, because it was filed in the case. Courts, as cited in our brief, have repeatedly found that that testimony is sufficient to meet your initial burden at a Travers hearing, the entire purpose of which is to determine whether the affidavit of service accurately represents what occurred. The fact that he could not recall the date of service, which was more than 11 years before the Travers hearing, is not dispositive. And in fact, courts have repeatedly held that it actually enhances his credibility, because he testified truthfully that he could not recall something that happened 11 years ago, in the hundreds and possibly thousands of service attempts that he's made over the years. It's also not dispositive that he didn't have any other records, such as his field notes, because again, the passage of time is such that it's reasonable for him to have disposed of those records, and the general business law only requires that he keeps such records for 2 years, I believe. Ultimately, this case came down to credibility determination by the trial court. There was a Travers hearing. The process server met his initial burden by testifying that it was his signature on the affidavit of service and providing information about his general business practices for creating affidavits of service. The appellant had a chance to testify along with 2 witnesses. The court found that the process server was credible. The court found that the appellant and her witnesses' testimony was not credible and was rife with inconsistencies. Therefore, they denied the appellant's motion to vacate.
Counselor, do you agree with your colleague's response to Justice Kern's question that I think your colleague, whether or not the objection or the contention that is in front of us today was the same contention put before the court below in terms of the admissibility of that affidavit?
I do not agree, Judge. I think he made a general objection, but I do not believe he referenced any of the specific objections at the hearing, as he noted in his papers.
Okay, Counselor, I think we're all set. Thank you very much, both of you.
Thank you.
Thank you.
Number 176, Newco Capital versus MD Power. The appellant has submitted, and the respondent is by video.
And good morning, Your Honor. If you can see me, let me make sure I can see you. Yes, okay.
Good morning, Counselor. Can you hear us okay?
I can hear you. Can you hear me?
Yep, the appellant has submitted. Anything you'd like to say?
Just very briefly, this is yet another case in a row, second case in a row involving service. We have an MCA matter here, and in this case, service was made via certified mail, return receipt requested. There is an address listed on the MCA agreement as to where mailing should be going. It should be 2268 Landmeyer Road, Suite F, Elk, Grove Village, Illinois. I think that's a typo, but I wasn't there at the time of the formation. Elk Grove Village, Illinois, and then a zip code at the end. If you look at the written affirmation of service by
you want us to compare those just like the Supreme Court did, correct?
Yes, and
they don't match.
They do not match. The written affirmation of service prepared by plaintiff counsel does match, but if you slide down one page below it, you're going to see the actual green sheets, the certified mail green sheets, and they do not match. If you look at every single green sheet, it's sent to the wrong address. It's sent to Rockford. The physical address for the party is Rockford, Illinois, and I'm working from home, so hold on a second.
It's annoying, isn't it? Happens to me all the time.
The beauties of working from home. If the party herself lived at an address set 975 North Main Street, 104 in Rockford, Illinois, but that's a problem too because none of the green sheets say Main Street in Rockford. They all say Landmeyer Road. So while I have no objection to the idea that certified mail return receipt requested is a valid method of service, it was agreed to by the parties, it has to be sent to the right address. It wasn't sent to the right address. So there was no service.
Okay. Thank you very much, Counselor.
Thank you. Take care.
177 is submitted. 178 is over the term. 179, I believe, is settled. That leads us to the last case on the calendar for oral argument, 180. Bliss versus Henry Schein, Inc., and both counsel are appearing by video.
What do you think?
There we go. We have one, and now it looks like we have two. So I'll start with Mr. O'Connell, sir. I think you're first up. Can you hear us okay?
I can hear you, Your Honor.
Perfect, we can hear you. So, Mr. Kiley, let me just test the mic. Can you hear us okay? And let's see if we can hear you.
I can hear you, Your Honor.
We're all set to go, Mr. O'Connell.
May it please the court, my name is William O'Connell from Goldberg Segala for defendant appellant Henry Schein, Inc. Your Honors, this was a summary judgment motion that is sort of overloaded by the 10,000-pound gorilla in the room, which is the massive comparative negligence or sole proximate cause of the plaintiff in this case. That's our belief. But our expert, who was very well qualified in this case, made a very strong prima facie showing that there's no defect, there was no negligent installation, and that there was no causation by anything that the defendants did. The argument, I'm not going to spend a lot of time on any defective product because there really is no argument by the plaintiff about defective products or inadequate warnings under strict products liability law, as I understand it. I know a plaintiff can prove circumstantially a defect, but only when he can exclude all other possible causes not attributable to the defendant. And here, he obviously cannot exclude his own comparative negligence in what happened here. So that's not possible. But expert Kane.
Counselor, isn't there a question? Counselor, isn't there a question of whether or not there's comparative negligence here? And there was a witness that testified that Mr. Bliss was standing on a surgical chair with wheels, and that it may have rolled back while he was standing on that and basically pulled the cabinet down. And the question of whether or not...
That's exactly the allegation. And in fact, I would urge your honors, while you're reviewing this case, if you review to page 765 of the record on appeal, is a photo of the cabinet while it was elevated right after the accident with the rolling chair right next to it. And also on page 342 of the record on appeal is plaintiff's own testimony that he was a 230-pound man at the time of this accident. And if you look at that picture, you'll see it's almost impossible to be kneeling on that, as he claimed, and much more likely by his employee who testified that he was standing on it, it slid out from under him. But
Well,
that's,
isn't that actually a question of fact? Then we got two stories. We got the.
it is, Your Honor, but I think in viewing this case, it's impossible not to view the evidence and the allegation that this was not standing on a chair when all the other people, employees at the place said it was. But we move on. Our expert submitted a prima facie showing. He's highly qualified. He said these cabinets are well-known and accepted design in the industry. He said if a cabinet was improperly installed, like by over-tightening as claimed by plaintiff, there would have been signs over 6 years that it was loose or coming loose or about to come loose. And there were 0 complaints in all that time here. And a plaintiff and his assistant, who said he was standing on a rolling chair, are there on a daily basis. And they would have had some indication that that was coming loose. But Kane also said that the toggle bolts were capable of supporting the cabinet, that the cabinet itself, even with property supplies in it, as plaintiff alleges, it was strong enough to withstand that load. What happened here was an added significant and sudden load that pulled it off the wall. Our experts' post-accident analysis said that it was failed by an overload of the trunnion nut. There's a picture on page 1034 of the record. Of
Mr. O'Connell,
yeah.
Mr. O'Connell, let me just take you back to, I think the question that, as I understood it from Justice Montour, the expert based it on one set of facts and testimony, that is pretty much everybody else in the room. But the plaintiff, Bliss, testified that I didn't put any pressure on the cabinet. I didn't pull on it. I was merely steadying myself. I mean, don't we have to, in this posture, on summary judgment, have to presume the truth by giving every favorable inference to the plaintiff, the non-movement, on that testimony? And if your expert's affidavit is not based on that testimony, then it doesn't carry the burden of you. That's sort of the critical area that I'm focused on. I'm not sure that, because we can't weigh the testimony. So that's my question for you.
Your Honor, I better understood. I apologize for deviating slightly. It's our position that the plaintiff experts don't offer any negligence and causation to make this case a negligence case, irrespective of whether you agree with what the plaintiff says was the cause of this accident or that he didn't do anything. The plaintiff's experts rely on industry standards, but they don't actually cite any industry standards. They just keep saying that they're there and they're national and there are any standards and there are multiple standards and the defendants violate all of them. But under Your Honor's Court of Appeals and intermediate appellate case law says that's not enough. You can't rely on your own personal belief. There has to be concrete proof. And in this case, there is none. But it's not only that, he also relies on unproven facts. And as I point out in my reply brief, there's a reference in Jason Davis's testimony. He states that he put this into a wall stud and it was a steel stud. And plaintiffs just overlook that and rely on their expert who says it wasn't in a wall stud. But their expert wasn't there on the date of installation, and he was there at an inspection many years later, but he wasn't there, and he has no he doesn't say we looked through the wall, we measured things. He doesn't give any of that. He just says it wasn't connected to a stud, conclusory as a matter of law. And our expert, one other opinion that's very important, said that even if it was nailed into a stud, the same thing would have happened, and therefore there's no proximate cause as a matter of law. So even if you believe plaintiff was doing what he was doing, and in this case it was nailed into a stud, our expert says that it was going to happen anyway because the wings failed, and we know that because if they didn't deploy, they would have gone in and come straight out. And they didn't do that. They went in and they deployed. And then it's our position. I know plaintiff says he didn't give any force, but at some point, a plaintiff was up there with his hand on the door and it comes down, and it's our expert's position. And he's certainly, as an engineer, qualified to say that that's when the wings broke. Have been insecure over the next 6 years, and our expert says that. So there's really, in our view, no
Mr.
negligence or no
Mr. Connell, can you hear me okay? But I'm going to ask you to wrap it up fairly soon for us, please.
Yes, Your Honor, I will. Your Honor, it's plaintiff's allegation that my client violated its own instructions because it has to hit a stud. But in reality, on page 927 of the record, there's a document which is the instructions that he refers to, and it says the installer must hit one stud per bracket.
Well, it looks like our videos have a bit of an issue.
Can you still hear me, Your Honor?
Yes, we can. I think the connection's getting cold due to the weather, but we'll do the best we can.
My argument, but I'll finish up quickly, Your Honor. My point is that it doesn't violate the instructions. The instructions say the installer must hit one stud or use a wall bracket where studs are not available. So in our own instruction, in mid-marks, the manufacturer's instructions, it says as an option, if you can't hit a stud, you can use one of these toggle bolts, which is a wall bracket. It's our position that this video was completely different circumstances, and then over tightening would have been known to all the people who use this on a daily basis. Okay. And with that, Your Honor, I defer and I thank you very much.
Thank you, Mr. O'Connell. Mr. Kiley.
Yes, thank you, Your Honor. I think I can still say good morning, and I guess I'm last but not least. Your Honor is correct. Mr. Kane, the defendant's expert's entire testimony is predicated on the version of the facts that are in dispute. Mr. Bliss, Dr. Bliss, says he doesn't dispute he took a chair. He said he had lighted the chair, had his knees on the counter, and had his left hand on the top of the cabinet while he was pulling things off the cabinet, and it came down on him. Now, there is a dental assistant, the only other person in the room, the only one who gave any sense of what happened. She's testifying that while she's cleaning up from the previous patient and preparing for the next patient, he took the stool, he stood on it, and the stool came out from under him, and he dragged it down. He denies that, so that's an issue of fact. There's also an issue of fact as to how the cabinet was installed. Now, I disagree with my colleague. I do think that a cabinet maker who's been installing cabinets for 40 years can testify as to the method in which a cabinet should be installed. But beyond that, he's a fact witness. It was a court-ordered inspection. He went to the inspection, unlike the defendant's expert. He actually physically inspected. They took the cabinet off. They took the mounting strip off. They could see that the three holes were drilled not through studs. It was only after in the incident itself that Herb McCauley, who worked for the hospital, put the three screws back in, and then additionally secured the cabinet directly to the wall through studs. So, at minimum, there's an issue of fact as to the fact that the manufacturer's instructions were not followed because there were studs. Ultimately, they were, after the accident, studs were used, but they were not used during this installation. On top of that, and I would submit that my expert, who's been installing cabinets for 40 years, can certainly testify as to the proper method of installing a cabinet in his experience. And in his experience, not securing it through a wooden stud or backing is not stable and is likely to bring the cabinet down. Now, this is also corroborated by the defendant's own witnesses. So first of all, Antrim Stewart, who was the manufacturer's design quote specialist, his initial drawing included a 2x6-inch wooden backing. John Shevlin, who was Midmark, the manufacturer's engineer himself, also an engineer, said, no, absolutely, confirmed that the manufacturer's instructions required installation through a stud. And then said not doing so would likely lead the cabinet to come down over time through gravity. The defendant Shine's own installer, Jason Bayholtz, testified as well that you would never put a cabinet up like this just through the sheetrock, that you need to secure it through a stud. Now, the expert of defendant, I guess, says, well, you don't have a PhD from MIT, so you can't testify as to the propriety of installing the cabinet through a stud. But, oh, by the way, even if they weren't installed through studs, it would have come down anyway by the force of the plaintiff, hanging on it, which, of course, the plaintiff disputes. But it's interesting to note that the defendant's expert absolves himself of the same responsibilities that defendant accuses the plaintiff's expert in, and offers no testing to suggest that, even if studs weren't used, it would have come down. He simply looks at the photo of the trunnion nut taken on the day of the accident and says, well, listen, the wing was broken, and the only way that could have occurred would have been if the defendant hung on the plaintiff hung on the cabinet door. Our expert, the significance of the video is to show no. Our expert theorizes and demonstrates through demonstrable evidence, a picture is worth 1,000 words, that no, the wing nut can be broken if it's over tightened, which is likely what happened here.
And you would say, Mr. Kiley, at a minimum, there's a question of fact about the negligence installation. At minimum, there's a version of events which suggest and testimony that suggests it was not secured. There's evidence beyond my expert from 3 other independent people testified in this case that no, it has to be secured or it's going to come down through the weight of evidence. So there's an issue of fact here, Your Honor, that needs to be determined by a juror. Thank you. I'm sorry, I didn't mean to cut you off, Mr. Kiley. Are you all set?
I'll rest on my brief with regard to the remaining arguments. Thank you, Your Honor, for your time.
Thank you, counselors. Appreciate it.